Thank you very much. First, I would like to express my gratitude to Professor Muszyński for inviting me to the team and for all Central European Academy, especially for Katarzyna, Professor Shiazi, and my colleagues Marcin, Paweł, and Bartek. And today I would like to share some key issues on my research concerned the rule of law, reverse rule of law in legislation. The whole remarks will be in a forthcoming book. Today, I will focus on highlighting only some issues. First, I would like to say that the rule of law is the cornerstone of democracy and justice, and it ensures stability, freedom, and rights. The central theme of my presentation are, from the one side, the principles of legislation and the structure of the sources of law, and from the other side, the examples of abuses that undermine the rule of law in the context of legislation. In my research, I describe the model of legislation in Poland as a standard to follow under the rule of law, because it is the point, the pattern of control. And additionally, I examined areas where the standard is violated in the context of legislation when it is justified as reversing the rule of law. The rule of law is connected to the concept of law. In our legal culture, civil law or continental law, the definition and the concept of law are grounded in a positivistic approach and a formal context. So the concept of law within the continental legal tradition assumes that the law is the product of the rational legislator, who creates a system of norms designed to regulate social life based on the authority granted by the sovereign. And this concept is built on the hierarchy of norms, where higher ranking acts establish the framework within which lower ranking norms operate. It is important for further remarks. Consequently, the analysis of the rule of law within the context of the continental legal tradition requires examining whether enacted laws reflect democratic values and comply with constitutional principles and human rights standards. Laws that fail to meet this criteria raise concerns about their alignment with the rule of law. So according to this concept of law, the standards of legislations and sources of law in Poland should be analyzed. The product of legislation, law itself, is an integral part of the rule of law. We have law, so it is the most important, in my opinion. It is stated in Article 2 of the Polish Constitution. About it, my colleague will say later. So, legislation is a fundamental process within any legal system, playing crucial role in functional of democratic states. It can be examined from several perspectives. It is at its core, legislation is a process through which legal norms are created. From the other point, it encompasses the outcomes of the process, so namely normative acts. Additionally, legislation involves the actions of authorized bodies and trust with lawmaking process. So we have, from the one side, process, then the result of the process, and actions of the authorities the legislator. The requirements of the rule of law are fulfilled through legislation where all these elements, process, product, and authorized activities are properly implemented aligned. I don't intend to give a lecture on Polish constitutional law, but rather to highlight the most important issues from the perspective of my research. I would like to point out some information on sources of law, of law in Poland, because it is important to research this violation of the rule of law. So first thing, the constitution is the supreme legal act in Poland. Second one, sources of law are divided into two categories in Poland: universally binding law and internally binding law. Universally binding law applies to everyone under Polish jurisdiction, and internally binding law are directed at entities that are subordinate to body that enacts. It is also important because, as we see, this mixing universally binding law and internal binding law is the very crucial problem today. There's, of course, the hierarchy of sources of law, ensuring the lower ranking acts comply with higher ranking ones. It is also from the principle of constitutionality. And one more, in Polish constitution we have exact provision on governmental acts, regulations. These are based on statutes and cannot modify them, and regulation can only address issue explicitly authorized by statutory provisions. So if something is not in the statute, it couldn't be in the regulation. The principle of legislation, the principles of lawmaking in Poland are designed to ensure the legislative process with values, norms of the democratic rule of law, state rule of law, and I choose the most important, in my opinion. It is the principle of legality, which impress on obligation of on the legislator to act within the boundaries of the law. This means that the legislative process must be conducted in a legal way, and the legal acts must comply with constitution, so conformity with constitution. Of course, from Article 2, we can interpret the principle of loyalty. From this principle follows that idea of building citizens or other individuals' trust in the state and laws it enacts. And it is very important also in the perspective of analyzing the rule of law. And the last two are proportionality and adequacy of a legislator. These are measures that which shows us that legislative actions should be proportional and adequate to the aims that legislation would gain. These principles are used by Constitutional Tribunal to verify if the lawmaking process is legal, so it is also important as a pattern of control. During my research, I identified instances where the rule of law was violated under the pretext of upholding it, as claimed by the authors of such actions. Professor Muszyński said already. So the authors said that it is according to regain the rule of law, but it is against the rule of law. These violations occurred in various areas of legislation, including violation of the constitutional system of legal sources, using extra legal actions as normative sources, and violations of principles of legislative process. This practice not only contradict the rule of law, but also erode trust in legal system and governance. And from this first point, the violation of the constitutional system of legal sources, I could point three main problems. So replacing generally binding law with internally binding law, regulating matters reserved for higher education acts with executive regulations, and the last enactment, the laws modifying constitution. Replacing generally binding law with internally binding law, I connect with the problem of resolutions of Sejm. So in legislative activities, a concerning phenomenon can be observed where legislative authorities empowered to enact laws and amendment to constitution adopt resolutions intend to have a generally binding force and produce specific legal effects rather than issuing acts of universally binding law. I would like to mention three resolution of Sejm on restoring legal order and ensuring impartiality and reliability in public media and the Polish press agency. It was the first one. Second one was the resolution of Sejm addressing to the consequences of constitutional crisis, particularly regarding the institutional position of and functions of the National Council of the Judiciary in a democratic state governed by the rule of law. And the third one is focusing on the consequence of constitutional crisis, particularly to the Constitutional Tribunal. These resolutions are not in so the resolution is not universally binding law, and they were claimed to merely declare certain facts without legal force. However, in practice, entities outside Sejm, not inside, referred to this resolution to justify actions such as failing to initiate procedures for selecting candidates for judges in a National Council of Judiciary. There's no universally binding law that allow it, but it is the base of this institutional fact. Second one is failing to initiate procedures for selecting, refusing to recognize Constitutional Tribunal and publish its judgments, and so on and so on, all these things. So, for example, on the basis on this resolution on Constitutional Tribunal, General Prosecutor or the Ombudsman refuse taking part in proceeding in front before the Constitutional Tribunal, and also making changes in public media also were based on this kind of resolution. And here is the very important problem, because from the one side, the authors are aware that it is not the source of law, but from the other, they impose on other bodies and also on private entities to follow it, justifying it that it is because of the rule of law. So here we have clear reversing the rule of law. So to sum up this context, replacing binding law with internally binding resolution undermines the rule of law by disrupting the hierarchy of legal sources and the principle of legality. The rule of law requires public authorities to act based on norms adopted through democratic legislative process. Such practice increases the arbitrariness of governmental actions. reduce legal transparency and erode trust in the legal system, thereby endangering the stability of the democratic state governed by the rule of law. What's interesting, resolution of Sejm is internal act of Sejm, but the initiative to make this resolution were from not even from the deputies. It was from the Ministry of Justice and from NGOs, some NGOs experts. Even it was prepared outside the same. So it is something against the rule of law, in my opinion. Okay, this other thing is a violation the legal sources hierarchy. And here we have many examples. Instance of violation of the hierarchy of legal sources can be observed in actions where executive authorities exceed their delegated powers, regulating matters reserved for higher ranking acts, or even encroaching on government's issues exclusively reserved for constitution. I have here the example of the regulation of Minister of Justice amending the rules of procedure for command cards. It imposed obligation on judges regarding to application of EU and international law in education. It is also against the main rules of legislation. If the lower act imposed to following higher act. This regulation established specific condition for judge recusal and introduced two categories of judges disappointed before and after 2018. So the purpose, as it was justified of this regulation, was to ensure to enforce application of EU and international law within the Polish legal system. But there is a question if it is the way of fulfilling some obligation, international obligation. This this regulation was against the statute. The minister wasn't empowered to regulate such things in the regulation. If so, it could be, but I'm not so sure. Some of these elements could be maybe regulated in statute during this all legislative process, but this imposing on judges following these judgments of international courts or following EU and principle of primacy, the regulation is not this level, and also sharing these judges into appointed in some point was something totally not in the context of the rule of law. Constitutional Tribunal said that this regulation was illegal, but I wrote it in a book chapter, the explanation how it was, because now as the judgments of Constitutional Tribunal are not published, so we have the problem of the status of these judgments and their influence on the legal system. So to conclude this part, while the regulation aimed to standardize the application of EU and international law, its legal form and the absence of appropriate statutory delegation raised serious doubts about the compliance with constitutional principles of lawmaking process. So such overreach by the executive undermines the rule of law, disrupts the hierarchy of legal sources, and erodes the independence and coherence of judiciary. So why do we need Sejm? Why do we need Senate if we can make legislation via governmental bodies, so we can do everything? Another thing is the enactment of laws modifying the constitution, and the best example here is the new law on constitutional tribunal, when not even in the main act, but in introductory provisions, there are provisions that are against, and that they are modifying the state of the judges, the character of the judgments of the Constitutional Tribunal. This controversy has been debate in Poland, and main criticisms relate to issues such as legislative procedure, the representative of public consultation, and also the case now is in Constitutional Tribunal, so we will see what happened. Another thing is replacing formal sources of law by extra-legal actions. Instead of using sources of law, not matter formal, universal or binding or internal binding, sometimes something different become a source of law. These are guidelines, for example for guidelines of Minister of Health on abortion matters. So they don't like the statute on protection on unborn kids. So they made guidelines how to use it instead the statute, and how to not follow the judgment of Constitutional Tribunal. And also this problem with the national prosecutor, when the basis on this problem with national prosecutor wasn't the provision, because it wasn't temporary provision, but it was an opinion which shows that it was something different. So the change in the prosecution of office was made by on the basis on this kind of interpretations and opinion. And the last thing, I think, these are problems with violation or reversing a rule in legislative process. Two examples. First, very clear when the Marshal of Sejm did not allow to vote of the two members of parliament. So this was because of its own decision. Marshal didn't want to follow the judgments of the Supreme Court, and so he refused to them for voting. So it was against the legal procedure connected with lawmaking process. Also this element I am describing in the book. And second one is on governmental level. So the regulation on the Minister of Education on the religion lessons. There was a requirement to make an agreement with religious organization to enact this kind of regulation, and it was enacted without this. Totally. It was not consultation. The law states that we should make agreement to enact it. So it was obviously and clearly against of the rule of law, and it was also justified of religious freedom and so on and so on. So it was justified, this amendment, with the arguments of the rule of law. Okay, so to sum up, the relationship between law and the rule of law is crucial to understand how the state and society function, and law forms the foundation of the rule of law. Without a legal system, there would be no framework to regulate social and institutional actions. So without law, there is no rule of law. Abuses of the principle of the rule of law in the legislative domain have profound and multifaceted consequences, negatively affecting the stability, predictability, and integrity of entire legal system. Such abuses weaken the rule of law, make a kind of relativization, and it is weakened as a foundation of democracy, leading to the situation when a law ceases to serve as an instrument for protecting citizens' rights and instead becomes a tool of arbitrary actions by those in power. A detailed analysis of various aspects of this issue reveals how actions undertaken in legislative process undermine the foundation of a democratic state governed by the rule of law and erode citizens' trust in state institutions. So justifying reversing the rule of law by violation the rule of law is not the way to protect the rule of law. Thank you very much.